Good morning. First case AR 2020 SC 5495. Chutturam Chunturam versus State of Chhattisgarh. AR 2020 SC 5495. Chunturam versus State of Chhattisgarh. Here they say, though witness knew about the victim and after seeing the assault on his known victim, he remained quiet. Therefore, that his ordinary reaction did not inspire confidence. Therefore, his testimony deserved to be discarded. This was the verdict. This may help you while conducting the case. But my humble request is that if the witness did not, you simply put your question uh, uh, on seeing that how long you remain quiet, then on which date you have deposed these incidents to the IO. Don't put a question that why you have not immediately reacted or why you have not reported. Then you may give some qualifying answers that may prejudice your defense. But at the same time, you can argue that case that about is and you must verify when the 161 statement of that particular witness who was an eyewitness and given late information, on which time and date that reaches the court. Sometimes what happens, they file it along with the final report. That is most important. Then one important case, this is Afiel Khan versus State of Madhya Pradesh. Afiel Khan, AFJL, Afzal Khan, State of MP 2019, Criminal Law Journal 5003. Afzal Khan versus State of Madhya Pradesh 2019, Criminal Law Journal 5003. There they have described about the autopsy and the presence of rigor mortis, and by all observation they came to know that the death may be within 24 hours of post-mortem and simple in nature. All the injuries are simple in nature. You have to go through that also for your increasing medical jurisprudence knowledge. Then another important case I would like to discuss with you was, what about burn injury? See, this is Ramu Goswami versus State of Tripura, 2019, Criminal Law Journal 1887. There they say dermal burn injury means only dermis, layer of skin were affected due to burn injury. So they say that is not sufficient to infer that torture was of grave nature which drove the victim to commit suicide. Somewhat a different ratio. The accused was arrested despite the fact that he took her to the hospital and he was arrested while purchasing the medicine. Then another case, most important, that is Francis Xavier versus State, 2020, Criminal Law Journal, Madras 3094. Francis Xavier versus State, 2020, Criminal Law Journal 3094, Madras High Court. Here they say there was hymen was intact, no external injuries. All that to show that there was an attempt of rape, not rape. So conviction was 511. For this area, I would like to draw your attention to General Classes Act. Lot of words you have to follow, not only observe, follow. Particularly, see in this case, rape case, the 376, 511, But probably this incident was before amendment of 376. So after amendment, there were so many things. If suppose this rape is on child post-co act, then penetration is not sufficient. So many things are there. So the date is most important. What all are the important General Classes Act? Calendar is important. We follow Gregorian calendar, and the time is important. And what is holiday under Negotiable Instrument Act? What is holiday under Non-Negotiable Instrument Act should be understood. Time of death when simultaneous death occurs. These things are most important for General Classes Act. If there was a word that person includes male and female, and sometimes the General Classes Act also permits to presume that if there was a address male, that denotes female also. These things, a lot of things you must understand for your career. Best wishes.